suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Our real good lawyer has got a mind like a steel trap. He walked in the door here at the studio, took one look at me and went, Virginia, I remember you. You see, nothing gets past this man.
What's 4 months between friends?
David Whiting, good morning.
Good morning.
How nice to see you.
Very pleasant to see you.
How'd you get on without me?
Oh, your stand-ins did a good job, I must say.
They're excellent.
Yep.
I know, never go on holiday, they say.
Yeah, I think, the answer is you go on holiday. I mean, look at me. Never go on holiday.
You're always on holiday. He's giving
Really?
me a dirty
He says,
look
I'm just
now.
trying to think when. Okay, never mind. Okay. I do take them. I tend to sneak off on a Tuesday afternoon and come back on a weekend.
As you should if you can. What's your news? Anything to share?
We had we had 2 questions from last week, and I got 3 emails over the weekend in relation to Porter Davis.
Oh, did you?
So in terms of the responsible serving of alcohol question from last week, it was a caller who worked in a tourist bureau where they sold wine from local wineries. And he wanted to know whether or not he required a responsible serving of alcohol permit, and the answer, or certificate, and the answer is yes, he did.
Yes.
But he doesn't get the penalty, his licensee does. So the bureau, which will have a packaged alcohol licence, is up for $1,100 for every person who works for them selling alcohol who doesn't have an RSA. So that would be important. Then the other question was a caller in relation to a drainage issue from an owners corp. That what had happened was there'd been some flood damage, the carpet replaced, and then the question then was who was responsible when the flood happened again, but more significantly a few weeks later. And my question was really whether you could take it to VCAT under the Owners Corporation list, and yes, you can.
Oh, okay.
Yeah.
Right.
And then in relation to some emails I got relating to contract repudiations in relation to the 1,000 properties or so that were the contracts were repudiated by the liquidators on behalf of the company. 4 things to think about. The first one is grab yourself a building consultant who will be able to do a detailed analysis of the work done, and that's useful for 2 purposes. Firstly, for quantifying any claim you've got to make under the insurance.
Yes.
And secondly, as a starting point for any builder who's engaged to finish. Because if a new builder comes along and gets to finish the job, there'll be a question as to what are the claims made in respect of the Porter Davis insurance, and what are the claims made in respect of the second one.
Well, there might not be any insurance in the Porter Davis.
No, for the ones, if they've started, there's insurance in place. For those ones, yes. If you don't have insurance, I'm incredibly sorry for you.
Yeah, exactly.
And then it's making the site secure.
Yes.
Because at some point those fences will be taken away. And thirdly is start looking for a new builder.
Gee, it's hard, isn't it?
Yes,
Incredibly
although I
difficult.
thought the article in yesterday's paper was a glorious exercise in the cynic in me tells spin, telling it was the good news of 375 people who are getting their properties finished.
Yes, exactly.
And somewhere in there they talked about the 1,000 people or so
who
were not.
Yeah, that's right. And that's just the townhouses anyway.
Mm.
But have you managed to have a look, and I'm not saying you should have, at what's required from the VMIA, the Victorian Managed Insurance Authority, and just what jurisdiction they have over this, and what sort of care they should be taking with making sure that the authorities that are reportable to them are doing the right thing with insurance?
What?
Oh, the organisations that they are responsible for, the area that they're responsible for.
No, the VMIA is to all intents and purposes an insurance company.
The primary provider of cover if a builder dies or becomes insolvent.
Yes, which is, we used to have a thing called the Housing Guarantee Fund.
They've reported a deficit. They're in deficit at the moment.
Because with the building industry in the state, it's in the answer would be we're running out of money.
Yeah.
I don't think we'll ever run out of money, but they are running out of money. So from their point of view, it's really up to the person who wants to make a claim on the insurance company to prepare their application and put it in. They are not builders. They're going to assess the figure that you give them and then try and work out what their liability is.
All right, let's get your calls, 1300 222 774 if you have a legal question for David Whiting. Henry in the Gambie, go ahead, good morning.
Good morning. Thank you for your time. We have a problem with our unit in Melbourne.
Yes.
The police evicted the tenant on a warrant about 12 days ago. He was in arrears with the rent. But his furniture is still in the unit and he will not or cannot pay for the removal. What do we do?
Have you considered putting it outside?
Well, what are the legal liabilities if we touch the furniture?
I don't know if there was an order made. What was the VCAT order made just for possession? And what's happened in relation to the bond?
The bond is there's too much. There's rent in arrears on the bond.
Oh, so the bond will disappear, will it?
The bond will disappear.
Yeah. You could treat them as unclaimed goods, and depending on their value, so have a look at the Consumer Law and Fair Trading Act, Australian Consumer Law and Fair Trading Act, and see if you can come up with a value of the items which are still in the property, and that will tell you what the process is you follow for disposing of them.
Right. Okay.
Australian Consumer Law and Fair Trading Act, Victoria, will talk about disposal of unclaimed goods.
Okay, good luck, Henry. That's a really annoying position to be in, though. No one has the time to have to run around doing that. Peter in Blackrock. Peter, what's your question? Good morning.
Good morning. I've got a problem with an individual who's moved into the area who's a removalist. And he's got 3 rubbish trucks, keeps parking in the residential streets and blocking our parking facilities and, of course, hindering the traffic. The council says because they're not long trucks over 7.5 metres, there's nothing they can do about it.
Yes, that makes sense to me.
Yeah, so they said they can basically stay there as long as they like. But I've measured one truck and I reckon it's 1.753. And the council says, no, we've measured a 2 and it's not. So they're stuck there weeks at a time, and I just wondering what we can do about it.
Well, it would seem to me, I mean, it's a sense like, I might come along and say I don't like the car of the being driven by the person who lives next door to me. I want the car to go. You've got to look at the parking restrictions that apply, and if the parking restrictions don't prohibit the parking of those vehicles there, that's the end of the discussion. You might go to council and say,
you can make
we want you
to.
Well, what you might want them to bring into parking regulations in your street for resident parking. You might want to limit the number of vehicles that a person can have.
Yep.
But I think that will give you more kickback from more neighbours than it will be from that one. So if the law allows it, then the person can park there.
Peter, sorry we can't help further, but thank you for calling in. Dale in Paran. Hi, Dale. What's the issue?
Hi, thanks for taking my call. So what's happened is in mid-February, I received authority to park my van in the loading zone of a hotel during the day. And then in the afternoon, I discovered that my van had been taken from the hotel, and they had said that they hadn't requested for it to be towed. I made a police report and insurance claim, and unfortunately the hotel didn't have any CCTV cameras in the area. And also confirmed it wasn't on the national towing database. Then a couple of weeks ago, I was notified by the police that the van had been located, and I found out that a private towing company had actually taken it. And so since speaking with the hotel, they've confirmed in writing for me that I did have authority to park there, and they didn't call the towing company.
Who authorised the towing company to remove the vehicle?
I don't know. I haven't been provided that information.
And what's the issue in relation to recovering the van from the towing company?
So I've had the van back.
Yes.
But since that time, I've had a lot of costs involved. I've actually bought a new van to keep the business running, equipment that was in there. So, yeah.
Right. And I suppose you have an action, but I mean, you're not going to get new for old. I suppose the question you get is, what do you measure your loss as being, Dale?
So the losses are around, I was renting a van for multiple weeks, but because within that time frame, the insurance hadn't paid out my claim. So now I have the van back and I have 2 vans. And I'd also purchased a lot of new equipment and. But
you have a bigger problem. You've probably got to give money back to the insurance company because you've got the van back now. or does the van now belong to the insurance company?
No, so because I hadn't finalised the claim, the claim is voided.
Yes.
So it's back with me.
You have an action for damages, Dale, and your starting point would be against the towing company that removed it, and they would then join as a third party or seek contribution from whoever it was who authorised its removal. But it's a magistrates court matter. It's not a VCAT dispute.
Okay.
It's an action for trespass to goods. And so we'll actually come back to work out from the towing company who told them they could take your van. And then it becomes an argument as to what your actual loss is, which will be different to what you spent.
It sounds complicated there, David.
Yes. Yeah.
So it sounds complicated there. There's my first mic problem since I come back. I think
that's a hard one.
Yeah,
yes.
That's right. Yes, indeed. All right, good luck. Sorry about the situation there, Dale. Chris in Fitzroy North. Go ahead, Chris. Good morning.
Thank you for taking my call. It's about water ingress in an apartment. The likely cause has been identified and repaired, so there's been caulking on top of the window. But now the owners' corporation say that further repairs to the wall, so inside the wall was saturated.
Yes.
There was a hole cut in the wall by the plumbers who came to investigate.
Yep.
So the whole wall needs to be replaced, painted. The insulation, I believe, needs to be removed and
replaced.
Renewed.
Yes.
Yeah, replaced. So they're telling me that's my responsibility now.
So what have they paid for? Nothing.
They've paid for the caulking on the window. And several visits of people to come and look at it and examine it.
Chris, if it's a owner's corporation issue for failing to maintain the windows, then the owner's corporation has an obligation to whatever happened as a consequence. So it's their responsibility to deal with the consequences of their want of maintenance. Right, so, but it's probably not covered by their insurance. How old is your block?
It's 4 years. The builder has refused to do anything.
It's not a structural issue, I would not have thought. So,
well, they think that the caulking was not ever done.
I understand, but it doesn't strike me as a structural issue, but more of the nature of a maintenance type issue.
Right.
I'd be coming along, well, I don't know, can I mull over that, Chris?
Absolutely.
I just want to play with it in my mind a little and see where I get to, and I'll tell you next week.
Absolutely. Thank you so much.
Thank you.
Thanks, great. Good on you. Thank you for taking that on notice, because it might be useful for other people as well. We get a number of those particular issues, once there's been
there's a leak, whose fault is it?
Exactly, and
who
the consequence that follows.
Yes.
That's right, yes. So it'd be good to clarify that one. Thank you very much. Where shall we go now? Neil in Seaford. It's a lovely part of the world. Hi, Neil. What's going on?
Good morning. My wife and I own a property in which our son lives and pays rent. We would like to give it to him now as his inheritance and have him sign a document saying he's received his inheritance, so the other children aren't affected. What are the implications for us?
How long have you had the property, Neil? Longer than you've had the child?
No.
Okay. Then what happens is that the transfer of the property will create a capital gains tax bill for you. So if you give away, I don't know, let's say the unit's worth $500,000 and you paid $150 for it, you'll have a capital gain of $350 and a taxable gain of half that. So there'll be a tax bill to be paid, and then there will be stamp duty payable on the transfer to your son. Now, if you leave the property to your son in the will, your estate doesn't pay any capital gains tax. Your son does when he sells it, and there's no stamp duty. So I understand your generosity, and you might make a promise and make it clear to his siblings that that's what you're doing, but you're creating an incredible rod for your own back in terms of your capital gains tax bill and also a stamp duty bill for your son.
So
Have I talked you out of it yet?
To some extent, yes.
Yes. So I just do think, though, the trick will be to make sure his siblings are aware of what you're doing and why you're doing it.
Neil, is there a powerful reason why it couldn't just be included in the will in your estate?
It's about timing, isn't it? You know, it's about helping children move on in a particular time that they need the security.
Yeah.
Okay. Then crunch the numbers that are specific to the transaction and make a new decision. It might be that your son is prepared to pay part of the bill. You know, here's a property worth $500,000, but I need you to give me $50,000 for the stamp duty and the capital gains tax I'm going to pay.
Okay.
So maybe just do the numbers and see if that does it. Did you very quickly want to add something else there, Neil?
What if we sold the property to him for a reduced...
Exactly the same. Yep.
Yeah.
If it's a non-arm's length transaction, will be considered to have occurred at market value.
Yep.
So it's the full capital gain and it's the full stamp duty.
Good luck with that, Neil. Crunching numbers will have to be done. But if he's living there and there's no dispute about being able to live there, and it's going to be left to him in the will and as part of his estate, Neil's estate, do you see a problem with that in terms of the security of knowing that it's yours?
Well, I don't know, Neil, but you wonder whether or not if you've got, let's say it's a third child and there's a long gap and the other two are settled and there might be some issues where you want the opportunity for this person to be properly established. That could be a reason why you want to do it.
So that there's no dispute brought about it later on.
Yeah, well, it's all happened, and you know, let's say the property goes up in value by another $100,000 before Neil dies, then you might get a bigger argument over the value of the property.
Yep. David, will you be here next Tuesday, Anzac Day?
Yes,
you will.
I have spoken to your producer, and I am told you were conducting a normal program.
I'll be here.
Yes.
Goodness.
So I said I will.
Well, honestly.
I know I won't get a park anywhere near here, but that's a different question.
Yep. We'll give you a cab charge. I just have to read this. Every now and again, my job allows me to be on the road, and every so often it happens that it's on a Tuesday. I love listening to David. His knowledge of his area, expertise is inspiring. There you go.
Nice.
Isn't that nice to
Very
hear?
nice.
Thank you so much for sending that in. All right, let's hand out some help. It's a tree over a fence. Naomi in Balaclava, what's going on?
Oh, hello. Thanks for taking my call. My query relates to trees and shrubs not being maintained along the boundary of our house. We live in a semi-detached house, and they're now getting very tall, and it's creating two issues. The first is at the front of the property where the power line comes from the power pole to across our neighbour's property and then splits to go across to our two properties.
Yes.
And that's now... the trees are getting tall, and I'm worried about in high winds what will happen if in case it comes down on the power line.
Yep.
And the second
you'll lose
issue,
power.
Oh, I'll lose power. Is there? I'm going to be writing them a letter, but is there anything that I can say in terms of do they have to keep that below the power line height? You know, keep the tree below the power line height?
I'd have a different approach, Naomi. I would be talking to the power company because they will be interested in making sure that their services are not interfered with.
I'm surprised they haven't stepped in and maintained that. They certainly do in my neck of the woods. They're there every other day.
Well, they're
it's
probably...
It's
not a street tree.
I get
not
that.
a street tree. It's
Yes.
on a private property.
Don't they necessarily have a view about that?
They will have a view, and they will be keen to ensure that the issue doesn't cause the service to fall out. So, Naomi, start with them. Right?
Okay. Right.
You also have the right to... You can go off to the magistrate's court to the extent that a neighbour's tree encroaches into your property. So are we talking about the encroachment or just the power line?
It's just the power line, yeah. I don't want to go down the legal route. It was just to understand what route I should take and if there's any and what law it comes under. So, but the power company's a good idea.
The power company, and the other one's trespass. The answer is the neighbour's tree is supposed to stay on the neighbour's side of the fence. But I would be pointing out to your neighbour that their supply line is affected by exactly the same issue.
Yeah.
Okay. Good luck.
And just briefly, in the back, they have a very large palm that blocks our sun in winter, autumn, and spring.
Can I tell you that easements of light disappeared in 1929?
Okay.
Yep.
So, no.
All right.
I know you'd
Just look at it and admire it in the shade.
You'd think that the light issue actually would matter, but yes, it doesn't.
You used to be able to create easements of light and air, and that disappeared, I think,
lovely.
in the late 1920s. So every now and then
Nice
you'll
idea.
find a lane
Yep.
in central Melbourne that references a easement of light
and air. It's the title of a book, I think. John in Keysborough, what would you like to ask? Good morning.
Yes. Hello, Virginia and David. I saw a property on the major real estate site, and I spoke to my agent who sold our property, and it was the same franchise that was selling the property, so he liaised with them, and I spoke to both the agent and the sub-agent, and the auctioneer. And at no time was it mentioned that it was actually a subdivision. In the advertising of the property, there's no mention that it was a subdivision. There was no mention.
So, John, can I cut to the quick here? What you've done is you've bought a property on an unregistered plan of subdivision, and the contract clearly provides that settlement will be on the later of a nominated date and registration of the plan of 14 days after registration of the plan of subdivision. So that's what it said.
Yeah.
So that's in the contract you signed.
Yeah.
So where's the problem?
Well, the problem is that they're unable to settle. They can't settle, and they've got me in on a licensing agreement, and they're charging me $500 a week.
Yes.
I'm on the age pension, and I get $500 a week, which is going to be stopped, and it's affecting my health dramatically. They've got no indication of when they can settle this.
Yes.
None at all. So this is ongoing, and it's
I can't understand why they've got no indication about when it's going to settle. They might not know precisely, but they should be able to tell you what stands between you and settlement. So I've contacted the council, and the council say I'm not a party to the subdivision, so that's a privacy issue. Yes.
And but there are indications that the owner is having financial difficulties with the funding the subdivision because she was unable to access the deposit.
Okay. Can I say, John, I had a similar issue in relation to a property where I was acting for the purchaser and the vendor didn't have enough money to finish the subdivision. What we actually did was I got my client to lend them the money to finish the subdivision.
Right.
We took a mortgage, we charged them a bill, we did all sorts of things, and I wouldn't recommend it to everyone in every instance, but if let's say they're $50,000 short in finalising the subdivision, you might choose to lend it to them. But properly secured by a mortgage on proper legal advice, so you might be able to achieve what you want and negotiate a lower rent while that's happening.
John, we'll have to leave that there. I hope that helps.
Okay.
Thanks so much, and good luck with it. This has come in on text. I'm working with David in a professional matter and must say that as an opposing advocate, it's the other side. As an opposing advocate, David is equally as polite as he is on your show. A classy lawyer that all should aspire to emulate.
Oh, my goodness gracious me. I've got to pay some endorsement fees.
Honestly, your mum and brothers and sisters are working very hard on the text line today, aren't they?
Yes, they are. Thank you.
We're going to have to, I think we'll have to inaugurate a chair in your name at Melbourne University Law, which will be sort of the classy, professional, polite chair of David Whiting.
Ethics.
Yes, exactly. You'll be here next Tuesday.
Yes.
Fantastic. Thank you, David Whiting. Always great to have him on board.